So Tony believes that this robber has jumped into the car. This is the getaway vehicle and they're fleeing. So he shoots at the truck. Unfortunately, it was not the getaway vehicle. It was actually a truck with a family who was out and about. And unfortunately, a 9-year-old little girl was shot and killed in that truck.
We are the Armed Attorneys. Today we're talking about a recent conviction in Harris County, that's here in Texas, one of our biggest cities, Houston. And this involved a person who was defending themselves from a robber. Now there's a little bit of a twist to it. So we're going to be talking about how these split-second self-defense decisions can, kind of unfold and things you need to be careful about. But before we begin, show your support for the Second Amendment by hitting that like button. And this is a wild and tragic case.
This is a very tragic case. This is the case of Tony Earls. His case was just heard and decided the last couple weeks. And basically what happened was on Valentine's Day in 2022, he and his wife were at an ATM and they were getting cash out of the ATM when a armed robber came up to the window, pointed the gun through the window at his wife, and ended up getting some property and ran away. Now that robber was never caught, has never been found to this day. Tony ends up getting out of the car after the robber and ends up firing shots. Now, I guess we'll kind of say that we're going to talk about both sides of this story. We're going to talk about how, the self-defense argument as well as what the state argued. So bear with me on the facts some. So what Tony says happened is that he gets out and what he sees is a truck drive by. He believes that robber has jumped into the truck and
it's
is
kind
now
of obscured
fleeing.
by a sign, correct?
That was my understanding.
Okay.
Yeah. Also, you have to remember that all of this is happening very quickly for any self-defender involved, right? So, when we're looking at these cases, when we're watching these videos, when a jury's deciding, they're able to slow things down. They're able to edit the videos to where, you can really see things. But all of these things happen very quickly in these emergency situations. So Tony believes that this robber has jumped into the car. This is the getaway vehicle and they're fleeing. So he shoots at the truck. Unfortunately, it was not the getaway vehicle. It was actually a truck with a family who was out and about. And unfortunately, a 9-year-old little girl was shot and killed in that truck. So that's the very tragic part. And even watching the trial, you can see, the defendant was crying most of the time. I think everyone agrees that this is an awful accident that happened that resulted in the death of a child, which is obviously just heartbreaking and tragic. So the kind of interesting part, the defense argued that obviously this was self-defense. A robber came up, pointed a gun at his wife, and you're sitting in a vehicle, right? So you're sitting close. So if a gun's pointed right here, it's close to Tony, it's close to his wife. Tony believed that the robber had actually fired a shot. Apparently during the trial, the ballistics showed and all of the experts that testified kind of showed that there was no shot fired by that robber. I don't think that matters for self-defense. If a person points a gun at you, whether they shoot or not, you still have the right to use self-defense here in Texas, at least. You use deadly force in self-defense to defend yourself in that situation. So whether or not that person actually shot around or not, I think, his attorneys could have made the argument that doesn't really matter for self-defense. The issue I think they focused on was the fact that the guy was running away. So, the DAs made a big point to show that this guy was no longer a threat. He was running away. I thought it was interesting that they kept saying that if it was defense of property, that this would have been justified that he was running away, but not in self-defense. I don't really know where the DAs were.
I think they were just trying to confuse the jury at that point.
Probably. That makes sense. So they kept focusing on that. The other thing they really focused on and they really harped on was a statute we have in Texas that says that if you are using self-defense, even if you are justified in using self-defense, if you accidentally injure or kill an innocent third party, that your act of self-defense doesn't actually extend to that person.
Yeah. So, and here are the logistics of that, because I think that's what folks are, really, really interested. You find yourself, and think about this. You're defending yourself against, one of these incidents in a crowded place. That's the most likely scenario where we see these things come up. And, there is a little bit of an interesting procedural history to this. He was originally arrested. They no-billed him. They found new evidence, which is, I don't think they found new evidence. They just had new people analyze the evidence. They indicted him for murder. Prior to trial, they dropped the murder charge. They proceeded on a manslaughter charge, and I bring all that up to say this is why it's tied in. We have, and most states have this in their law, where you cannot act recklessly and claim self-defense at the same time. So, think we have different mental states: mens rea, intentionally, knowingly, recklessly. Well, for self-defense, we're saying it's intentional. I did it. I did it on purpose. Here's the reason why I did it. And so, that would make sense if there's a limitation on a use of force or deadly force for reckless conduct. And so what is recklessness? Recklessness is when a person is aware of a substantial and unjustifiable risk and they consciously disregard that risk and they decide to take whatever action they're going to take. In this case, it was discharging a firearm. And so, we have that, and think about these different scenarios, and these are the ones that go through my head. You're at a public venue, a crowd of people, right? If you just start willy-nilly, shooting into the direction of maybe an attacker, but, there's a lot of people standing behind him, well, guess what? You might find yourself in this similar situation. So recklessness is key.
Yeah, the other situation that comes up a lot in recklessness is road rage situations.
Yeah.
So, if I'm in a car and the other person's in a car and they point a gun at me and I'm shooting at them, but we're on, let's say I-45 here in Houston, which is a major freeway, and there's 6 lanes of traffic and it's rush hour and there's people going. I mean, the chances of you actually hitting that person who's pointing a gun at you, or the gun going, the bullet going through their car and going into someone else's, I mean, that's another situation. But that is what the prosecution really focused on in their closing argument, was that this was reckless, that he shot into a truck, that he had no idea who was in that vehicle, and that was reckless behavior. And because it was reckless behavior, that even if they believed this was self-defense, they didn't get to really consider that part, they being the jury, because of the statute in Texas that said that even if you were justified in self-defense, if you were reckless, it doesn't extend to, a third party, an innocent third person.
Yeah, and I think if you're sitting there at home thinking through all these different scenarios, and this is what I do, and this is what I talk to people about, and you're like, well, if I did XYZ, would I get charged with this? Again, going back to those criteria, is there a substantial and unjustifiable risk? Did you know of this substantial and unjustifiable risk, and did you disregard it? And so take whatever fact scenario maybe you have in your head and apply that criteria to it. If you shot a perpetrator and there was an innocent standing behind him and the bullet penetrated them and struck the person behind them, I could see where, hey, maybe that's not reckless. You hit your target, right?
Yeah.
Are you aware that you're going to penetrate? Maybe not. So just take whatever facts you're thinking about and apply it. And that's what a jury is going to be asked to do. And now, he got all of his self-defense instructions, and that's kind of one of the issues that comes up. We see a lot of, if a case is going to get overturned, it's going to be based on the jury instruction. He got all those jury instructions, but before they were, to consider self-defense, had to address this recklessness issue. My gut says they probably didn't even look at this as self-defense. They just hung their hat on recklessness.
Yeah, and I thought it was kind of interesting. The defendant in this case ended up not testifying in the guilt innocence portion
that's
of this
what we're
case.
talking about.
Yeah, and I think that's interesting. In the self-defense cases that I have tried previously, almost always the defendant ends up testifying. Now, obviously, you have the right not to testify, and the jury cannot hold that fact against you. I've also had cases where the defendant does not testify, but a lot of times in these self-defense incidents, the person testifies because they get up there and they say how they felt in that moment, why they felt they were justified, what their feelings were, and get the jury to understand where their mindset was, to show that, he was scared, he had a gun pointed at him. I think the fact that the prosecution against made such a big deal about the fact that robber probably didn't fire a round, I don't think that matters. I mean, if someone's pointing a gun at you, you easily could think that they shot just because they're pointing the gun at you. That's a pretty scary situation to have a gun pointed at you.
Or you have people, it's a perception thing. I've seen cases where person unloads their firearm and they think they haven't even fired a shot, and vice versa. They thought they shot. I've had clients where they thought they shot, and then it's like, oh, there's one in the chamber and the magazine's full, so they didn't. So it's crazy what will happen to your perception.
It really is. It really is. He did testify in the punishment phase. So like Richard said, they ended up dropping the murder charge. They went forward on manslaughter charge. And so the range of punishment for manslaughter in Texas is 2 to 20 years. And the jury actually maxed him out. They gave him 20, which I was very surprised by that. Given the circumstances, given the fact that, I think, there was an argument to be made for self-defense. I was pretty surprised that they maxed
Yeah,
him out.
in the way that we bifurcate our trials, they're broken into two stages. First, did you commit the underlying crime? Yep, that's where they found him guilty. The second part of the trial is what we do in punishment. And I talk to folks from around the country, and they think this is absolutely crazy. But juries can assess punishments in Texas. Obviously, you could go to the judge if you wanted to.
Right.
But juries, we give them, we give the defendant the option to go have a jury assess the punishment. And it's this double-edged sword where, it's hard to get 12 people to agree on something. Maybe, they carefully reviewed the evidence and have differing opinions. Maybe you got a better shot at a lower punishment there. But at the same time, these are the people who just found you guilty. So, maybe that's not a good idea. So, very tough consideration. But in this second part of the trial, there was another firearm incident involving Mr. Earls. And I think, this tragic death of a 9-year-old girl, plus, hey, look, still using firearms and is involved in incidents. I think that's where he got sank.
So yeah, so kind of interesting how this all played out, how it played out with, the guy getting no billed initially, then true billed, charged with murder, reduced to manslaughter, went to trial, found guilty, maxed out on punishment.
And keep in mind, I mean, this is from 2022, February 2022 to September 2025. I mean, that entire time, their life is, I mean, the jury came to the decision, but it's like, in that meantime, you see how your life's on hold.
On hold. And this is the other thing I wanted to say about these types of self-defense argument situations. Again, you're making a decision in a split second, right? Something's happening to you right then. You're stressed, you're panicked, your adrenaline is up, you're excited. You think you're about to be killed because someone has a gun pointed at you. And when a jury goes back, they get to sit in a room where they actually have a bailiff sitting right outside. They're very safe. They know they're safe. They get to look at everything. They get to think through each scenario and, oh, well, you could have done this, you could have done this. And you're making a decision like that. So that's something that, is always good to think about in self-defense types of situations, and kind of how they'll play out. But, obviously, ultimately, incredibly tragic. A child's life was lost, which is just horrible. But let us know in the comments. What do you think? Do you think the jury got it right? Do you think this was a self-defense? Let us know.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And as Leslie said, don't forget to question in the comment section down below. Until next time, we're the Armed Attorneys.